Welcome to Environmental Law course, dear learner and viewer. In continuation to discussion about the Water Prevention and Control of Pollution Act 1974, in the last two lectures, we have taken note of the core provisions of the Water Prevention and Control of Pollution Act 1974, and we have also taken the legislative framework of the Water Prevention and Control of Pollution Act 1974, and we realized that how the entire mechanism through the paraphernalia of Central Pollution Control Board, State Pollution Control Board, and the joint board vis-a-vis the constitution of expert committee under the chapter 5th of the Water Prevention and Control of Pollution Act, starting from the mechanism of giving the consent system till the power of the board to seek redressal from the court of law, as well as the power of the board to give direction, which include the stoppage of the supply line as well as the closure of industry. We have seen that now the section 33 and 34 is really said to be a kind of a prosecutorial strategy for the prevention and control of water pollution. We have taken note of that there are two kinds of power which has been conferred on the board. The one set of the power can be said to be what we can call upon is the immediate response and mechanism by the board. This immediate response and mechanism by the board enunciate that the board can have an extraordinary emergency power where any accident or unforeseen event cause water pollution, then industries must immediately intimate the board for any kind of a discharge of the poisonous, noxious, and polluting matters into stream, wells, sewers, or the land. And then we try to see that the immediate response of the mechanism which is inbuilt under chapter 5th of the Water Prevention and Control of Pollution Act from the point of view of the disaster preparedness and the emergency power. We see that certain reasons are to be recorded in writing, and the board is enjoined under the duty to carry out immediate operations, including removal of polluting matters and disposing of it appropriately, remedying and mitigating pollution effect, and issuing restraining order and prohibiting further discharges. This provision happens to be a kind of a remedial provision, and this provision happens to be a kind of the emergency preparedness provisions. So we see that the emergency powers and the disaster preparedness are twofold. At the one hand, there is an elaborate mechanism where any kind of a likely apprehension of any kind of an accident or unforeseen event which have a tendency to pollute water, making it poisonous, noxious, of any kind of a stream, then the board sprang into action, and then after determining about its appearances and apprehension, then it can also undertake the massive remedial work. On the other hand, we see that the errant industry, the defaulting industry, is not complying with the mandate of Chapter 5th of the Water Prevention and Control of Pollution Act. Then Section 33 confers the board to power to seek the court remedy. This is a kind of a remedy which is a direct remedy which has been given to the board, and where certain remedies are conferred under Section 33, which talks about that the board has a remedy of the court of law, and board can go to the court of law for seeking appropriate action about the water pollution when it is apprehended by applying to metropolitan or judicial magistrate of first class for restraining the orders, and then the court will try to see a direct the polluter to desist from the action. Now, the kind of the provision is that one, there is a board, then there is industry, and then the court. So board and industry both are looking the court of law for ultimate decision in regard to the emergency power and the disaster preparedness or any kind of an accident or unforeseen event. Then what we see that in case of going to the court of law, So all expenses incurred by the board in the operation are recoverable by as polluter from the polluter as a matter of land revenue, areas of the land revenue. So this provision, we can say that this provision is something which is the application of polluter pays principle, whereas this is a precautionary principle. So one hand, the precautionary principles are applied by the immediate response mechanism. On the other hand, what we see, the court intervention power, because during the pendency of the petition to the court of law, the board will not sit idle, but board will try to see that whatever the noxious and poisonous material which has been discharged to the streams and wells and sewers, then it is going to be reclaimed by putting the some kind of the liability in regard to the expenses which are incurred. So the expenses which have been incurred by the board are to be realized at a matter of the land revenue. So we see that entire mechanism of the prosecutorial strategy for the prevention and control of water pollution is either based in the precautionary principle or based on the polluter pays principle. And in that way, we see the cardinal objective of the chapter 5th vis-a-vis the routine procedure, the procedure of search, seizure, taking analysis, sample analysis, and then putting conditionalities of the consent system, and then try to cancel and approve the consent system and the licensing. Besides that, what it tries to see that if any unforeseen or accident is likely to appear or apprehended, then there is another set of mechanism, and we have a different kind of a prosecutorial strategy in relation to immediate response and mechanism, emergency preparedness, remedial measures. On the other hand, the board and industry, when they lock their horns together, then there is a resort of the court of law. But when the complaint is filed under Section 33 of the Water Prevention and Control Act, then the board will not see that whatever pollution has been caused to the stream wells and sewers or the land, becoming it more poisonous and noxious, then whatever expenses are the board are incurring in operation and cleaning of the land and the water, that is to be realized. With this, the emergency power and disaster preparedness is the first and the foremost strategy, and that is called the prosecutorial strategy. The one hand, the board's direct power and board's indirect power involving the court of law. Then we see what is there under Section 33 that has also been brought to the notice of, that has been changed, and that change we see from the standpoint of view of Section 33A, which have conferred power on the board not to go the court of law, but it can directly hit hard to the question of what is the pollution, and that pollution are to be remedied by inserting into a kind of a provision, and that provision is that the board will not wait for any kind of the court order, and the power to give direction under Section 33 will be slightly moving to the power which the board can have a stoppage of electricity, a stoppage of the supply line, and after a stoppage of the supply line, if the board is not coming to the terms of the compliance of the Section 33, then there is another direct provision. That provision is that what we can say about prosecutorial strategy, and that provision is power to issue direction, and that power is inbuilt under Section 33, and it is a extension, logical extension of the emergency power and the disaster preparedness power which has been engrafted into Section 33. This section is a replica of Section 5 of the Environment Protection Act, which talks about, and it was inserted by way of amendment. That's why it is known as Section 33A. The Act confers sweeping suo motu power on board to issue written direction to any person, officer, or authority without court intervention. This is the difference between section 33 and section 33A. So the difference of one set, we should see 33 and we should also see 30A. The 33 talks about the court and it talks about without court. That is the kind of a remedy which has been provided out. And what it says, that power to issue direction under this section include power to direct closure, prohibition, and regulation of industry. So this is one power which is very unbridled power, sweeping power, which has been conferred on the board in 1987, 1988, and it is without going to the court of law. The other power which has been mentioned here is the stoppage or regulation of supply of electricity, water, or any other service, meaning thereby that the first, it is a kind of a gradual, the first mechanism is the stoppage, regulation, and supply of electricity. If this appears to be very deterrent, then the court will, the board will not go to the aspect of what we can say that the direct closure, because that is a very that is something very unbecoming to declare the direct closure of the industry. So before the closure of the industry, the other remedy happens to be what can immediate remedy, and we can see that, or we can say that the interim remedy or the interim order. The interim order in regard to this prevention and control of water pollution is the stoppage and regulation of the supply of electricity, water, or any other service. This is an interim measure, and that is the final measure that it can direct the closure and prohibition of the industry. Then, in the aspect of the prosecutorial strategy of the prevention and control of water pollution, this section 33 is said to be a very progressing and having a salutary impact, and now the board cannot take any kind of alibi and any kind of a defense that it is not having much power and it has not conferred much power to bring very heavily against the defaulting industry after the insertion of section 33A. Now we can see that the board should swing into action and can legitimately apply this power when the prevention and control of water pollution is not being carried out in the light of chapter 5th of the Water Prevention and Control Act. Then after the section 33 and 33A, we will switch over to section 34, and which talks about the rule 34 of the Water Prevention and Control of Pollution Rule, which talks about governing the procedures, that how it can apply the interim measure of a stoppage and regulation of supply of electricity, and then the written direction, time bound process, emergency and overriding kind of the clauses that is to be set, and how that section 33, which is a substantive law, then this is the procedural law, and this procedural law is to be applied in this context. This is a procedural law which is to be applied, and it is to be followed by the principles of natural justice, and it must be followed with a very transparent and accountable system. Having seen the prosecutorial strategy in matters of immediate response and mechanism applying precautionary principle, and section 33 which applies polluter pays principles, and we have seen the interim and the direct measures and the final measures by the board in relation to cutting the supply line and as well as the closure of the industry and its due procedural safeguard which are to be followed. Then we proceed to the penalty structure in the enforcement mechanism to buttress the point that how the prosecutorial strategy are going to be affected for the prevention and control of pollution. For that, we have to refer to section 7th of the Water Act, which establishes a very comprehensive regime of fine, penalty, imprisonment, sanction for the violation of the Water Prevention and Control of Pollution Act, and we refer to section 41(1), which it says that what has been ingrained under chapter 5th, especially chapter 5th and the section 22, 23, 32, 1C, 33, 2, 33A, all these violations and non-obedience and non-compliance of section 20, section 32, section 33, section 33A, then the 3 months imprisonment of the 3 months and fine of rupees 10,000 or both to be applied as a matter of the prosecutorial strategy. Then section 41 subclause 1 talks about a blanket fine, that the blanket rule has been provided under section 41 subclause 1. On the other hand, we see section 41 subclause 2 is talking the entire prosecutorial strategy, that this appears to be a one-time mechanism, and the section 41 subclause 2 is not one time mechanism, but it is a kind of a graded system or the graded offenses, which we can say, or the graded penalties system. And that graded penalty system is that the continuance of the order, continuance of the water pollution by any defaulting industry, that even after the application of section 41 subclause 1, if there is still some kind of apprehension about the water pollution and the airing industry is continuing the violation despite the mandate of section 41 subclause 1, then there is an additional fine of 5,000 per day for continued failure and conviction, and in this case the imprisonment will go to the extent of 1.5 years. So we see that there is a difference between the first time offender and the second time continuing offender, and then we see that the first time offense, the continuing violations, and then there are serious contravention. So the serious contravention, that is that the failure of continuing beyond 1 year after the conviction. If the conviction has been done under section 41 subclause 1 at one time and the conviction has been done for its subsistence of that offenses continuously, and still there are repercussions and impact on the water prevention and control of pollution, that noxious and poisonous pollutions is continuing, then in case of serious contravention, then section 41 subclause 3 that says that it will continue beyond 1 year after the conviction, and it will also result into the imprisonment of 2 to 7 years. In this respect, what we see that the perusal of section 41 itself, we see that at one place there is a conviction of 3 months, then the conviction goes to 3 months, then it goes to 1.5 year, then it ultimately go to 2 to 7 years of the imprisonment. And on the side of the fine, we see that the one-time fine of 10,000, then 5,000 per day, and then we see that if the fine is not working out very well, then there is no other remedy, and the prosecutorial strategy is being clamped in such a manner that the conviction from 3 months to 1.5 year to 2 to 7 years imprisonment it can be enhanced into. On the other hand, we see that whatever has been ingrained in the section 20, chapter 5th, and which start from granting of the license and the permission, then we see that the section consent order violation is being attracted under section 43 and 44, and section 43 and 42, 44 gravitate around any kind of the failure of the compliance of section 24 to 25 and 26. So the failure of section 20 and 32 or 33 and 33A is related to section 41, On the other hand, failure of compliance in matters of the prevention and control of water pollution from section 24, 25 and 26 are dealt separately, and that is dealt under section 43 and 44, and which prescribes imprisonment from 1.5 years to a period of 6 years with fine, and which can be enhanced to 1.5 years to 1.5 years to 7 years for the habitual violators. So, looking at the penological and sentencing pattern which has been adopted at one set of the violation, which is coming from section 22, 32, 33, 33A, and after that the violation of section 24, 25 and 26, we see that there is a gradual rise of the penalties as well as the imprisonment, which can go up to 7 years. In this respect, the other question is that the Act establishes under Section 47 to inflict liability and to impose liability on the corporations and the government officials, and by imposing that liability, and the no fault liability, vicarious liability, criminal liability to the companies and as well as the government, the section 47 says that the director, the manager, the officers liable when offences are committed with their consent, connivance, and attributed to their negligence. And this law has a very unique provision besides having imposed the corporate liability for the water pollution on the government officer and as well as the officials of the company by adopting the mixed bag of the liability principle, and that liability principle can be a criminal liability, vicarious liability or tortious liability, or that liability can also be strict, and as well as that liability can be absolute also. Besides, whatever the penal provisions are engrafted under section 41 and for section 43, 44, we have a provision of adverse publicity, and this is very unique to the provisions of the prosecutorial strategy of the Water Prevention and Control of Pollution Act, that it tries to publish the name of the second time and the habitual violators of the consent mechanism and all kinds of the compliances which are being deviated by the companies or the government officials. So there is a provision of adverse publicity by publishing their name to newspaper directly or in some conspicuous places to deter and to defame them, and by their defamation it is expected that whatever is to be brought, that they will try to comply with the rules and regulation. So at one place there is fixing of the liability which assumes tortious to criminal to stick to absolute liability and precautionary principles and polluter pays principle. Then these sets of liability are already applicable by the strength of section 47 of the Water Act. But other hand, we see that there is a very lighter side of the adverse publicity clause, and to bring these companies to the compliance, and even if that fails, the adverse publicity, then the ultimate remedy is to apply the fines and the imprisonment system. With this, we see that the prosecutorial strategy of the water law in this country, prosecutorial strategies for prevention and control of water pollution in this country goes beyond these provisions. And then we now talk about any kind of a conclusion. That conclusion appears to be that there is a need of any kind of a critical thinking, and the critical thinking is that on the ground reality we see that how this law is going to address some other peripheral issue or the core issue, and the core issue is in the prosecutorial strategy lies the groundwater regulation. There has been a plan under the 12th five-year plan to which have envisaged a model bill for the protection, conservation, management and regulation of the groundwater resources so that the water table and aquifers must remain intact and should not have the impact of the pollution. Now we try to see that whether this law having its a deterrent effect is approaching the question of emerging legal framework, and that legal framework is groundwater regulation, and that groundwater regulation which has been addressed in the 12th five-year plan by a subgroup which has drafted national water framework law recognizing the importance of the groundwater legislation. It also dwells on the aspect of the state subject under the constitution because the water still appears to be a state subject. So while adopting a prosecutorial strategy from the fines and imprisonment and from punitive to pecuniary remedies, now we are going to discuss that whether this law can offer some very fruitful outcomes in relation to controlling the contamination of the water table and the aquifers resulting into the pollution of the groundwater resources. In that respects, the bill which has been proposed as well as that the National Water Framework Law which has emphasized upon the groundwater resources that needs to be considered because we often question that the remedy which has been prescribed into the prosecutorial strategy will not be very successful unless we adopt a very amicable mechanism, and that mechanism is that how the question of water law or effectiveness of the water prevention and control of pollution law is going to create a sense of environmental sustainability or the water resource sustainability, looking at the very long-term ecological implications of the water augmentation effort and try to underline the formidable challenges of the climate change impact. On the other hand, we will try to see that how pollution control mechanism by addressing massive waste generation and the menacing pollution from various water sources are to be cured by the prosecutorial strategy and by clamping a more punitive and pecuniary system, and how we are going to have a very amicable resolution of disputes and conflict in settling the interuse and interstate water conflict vis-a-vis the use of water by the human being, plant, agriculture, irrigation, and industries, and how the broad goal of the fundamental right to sweet and potable water is going to be achieved in matters of equity, participation, and a large access. Lastly, how the Water Prevention and Control Act, because it will be too heavy and too exorbitant to expect something, that how the Water Prevention and Control of Pollution Act is going to address the question of privatization of the water resources and address the question of the fundamental right and the principles of equity by creating a sense of fair distribution, use, and control of the water resources for the present and future generations are something appears to be the emerging legal framework of the water law. Whether that is going to be answered by the National Water Framework Law in a positive sense involving center, state, and local government institutions, or by resorting to the fundamental right and public trust doctrine, and how the national Indian courts, high courts, and Supreme Court and District Court, along with the National Green Tribunal, uh, appears to address the question of which are very vital, which has been ingrained in National Water Framework Law, to inject and impress upon the basic object of the Water Prevention and Control of Pollution Act. Lastly, we can say that how the prosecutorial strategy of the Water Prevention and Control Law in its right earnest while addressing the question of the water pollution comes out of the recommendation of institutional capacity building, suggesting legal and procedural reforms, and as well as enhancing a very foolproof monitoring and compliance system so that it can move from prosecutorial strategy, which is based on pecuniary and as well as punitive aspect, can go right from 1 to 3 months to 7 years of imprisonment. Can we move to what we can call upon is a market based instrument to achieve the goals of prosecutorial strategy to abate, prevent, and control the water pollution by fixing some kind of a corporate social responsibility in matters of water pollution and enhancing some kind of the public participation in water resource management in this country. Ultimately, we can conclude that when we are going to have a prosecutorial strategy, then we are bound to look at the basic provisions of Water Prevention and Control of Pollution Act, but at the same time, we should very critically analyze the penology and sentencing regime which has crept into the Water Act 1974 from a very broader perspective of the emerging legal framework as well as the principles of fundamental right and equity and promoting environmental sustainability along with some very radical and systemic reform including introduction of market-based instrument in prevention and control of water pollution. With this, I thank and I wish you a happy learning.